You are about to enter the courtroom of Judge Zenos Parosos. The people are real. The cases are real. The rulings are final. This is Judge Power. In this next case, the defendant sprayed the plaintiff with a water gun, and now he's suing. Stick around to find out what happens next.
This is case number 66 on the calendar. Plaintiff is suing the defendant in a matter of assault brought by a water gun.
A water gun? This should be interesting. May the defendant please explain their case. This court is now in session.
Yes, ma'am, I'll explain my argument.
I'm not a ma'am.
Sorry, ma'am.
I'm not a ma'am. Tell your case or I will hold you in contempt of court.
Sorry, Your Honor. It all started when my kids were having a birthday party. They bought a bunch of water guns and water balloons and were going to have a big water fight. The plaintiff stepped outside while the water fight was going on, and being the friendly neighbor I am, I was planning on going over, passing her a water gun, and squirting her and running away. I presumed that the plaintiff would chase after me and join in on the fun, but being the misanthrope he was, she yelled at me and telling me she would sue. She ended up calling 911 and the police performed an unreasonable search and seizure, violating my Section 8 charter right under my legal rights in the Charter of Rights and Freedoms.
First off, I am not a sheep. And second off, how does that have any relevance with you assaulting me?
You being the Debbie Downer you are, called 911 unreasonably, which called the police to perform an unreasonable search and seizure for a concealed weapon, which I didn't have since your assault was with a water gun.
Order, order. You're starting to get on my nerves, pal. Simmer down. Will the plaintiff please give a statement?
Of course, Your Honor. Well, you see, I was walking around outside to grab my morning paper when, all of a sudden, my lunatic neighbor violently trespassed on my property and shot me in my abdomen region. He should be lucky that I am only charging him with assault rather than attempted murder. I would also like to add that his Section 8 charter right for protection against unreasonable search and seizure was not violated, since the police were making sure he could not cause any further harm to the public.
Well worded, good sir. At this time, I would like to see the weapon used in the assault against the plaintiff. I would like to clarify with both parties that this is the weapon used in the assault.
Toy, but yes.
Yes, Your Honor.
Interesting, very interesting. Do you have a proof of the assault? Such as a bruise, perhaps?
Not any physical evidence, Your Honor, but a lot of emotional evidence.
Clearly, you have been emotionally traumatized by this event.
Precisely.
Objection! You can't sue for feelings.
All I do is win, 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 no matter what. Got money on my mind, I can.
This is absurd. You can't call objection. This isn't even a criminal court. He's not a judge. He's not arbitrary.
That's what I'm saying. Are there any final arguments you guys want to make before I do my ruling?
Yes, Your Honor. Finding me guilty of assault violates my Section 11 rights, the Charter of Rights and Freedoms. My right to a fair trial. You must realize that I never genuinely assaulted this wimp. I squirted him with a water gun. I never hit him. He even said that there is no physical damage, only emotional.
Your Honor, he just stated in his own words that he shot me. His Section 11B charter rights are not violated since he just admitted it himself.
No, you can't use my previous statement against me. And allowing it in your decision would violate my Section 11 charter right in the Charter of Rights and Freedoms. The accused cannot provide evidence against himself in court.
That statement was not forced out of you by anyone except yourself, meaning either of your Sections 11D or your Section 11C legal right was violated. The plaintiff wins the case and accused is found guilty of assault.
No!
You are about to enter the courtroom of Judge Zenos Parosos. The people are real. The cases are real. The rulings are final. This is Judge Power. In this case, 40-year-old Casper Lincoln is charged with the DUI from driving a pink Barbie car. Will his case be dismissed, or will he be found guilty? Stick around to find out what happens next.
All rise for the Honorable Judge Power. This is case number 64 on the calendar. There's R.V. Lincoln, and the defendant has been charged with driving under the influence.
This is a criminal case. I'm an arbitrator, not a judge. I can't rule this case. Just make a ruling or something. Please be seated. You have been summoned for an unusual case. You were driving under the influence in a tiny pink motorized Barbie car. Will the defendant please explain your side of the story?
Thank you, Your Honor. You see, I was having some drinks with a couple of my pals, and I was a tad thirsty and decided to get a Slurpee from the gas station. I was driving and didn't want to get in my car, drive downtown, so I borrowed my bud's daughter's toy to drive down. And since I was lazy and didn't want to walk, my driver's license was also suspended, so I would have been charged with a double whammy, DUI and driving while suspended license, you know. And a couple nasty pigs saw me in the Barbie car and arrested me for driving under the influence. This violates my charter right under the legal section of the Charter and Rights and Freedoms, since no one can be arbitrarily detained or imprisoned. The police must have a valid reason for any detention. Section 9. Their arrest was stupid and not valid.
Watch your language. Will the prosecution please explain their defense?
Yes, Your Honor. I was on the final stretch of my 47-hour shift, and I observed a man behind the wheel of a vehicular automobile, swerving from one side of the road to the other. It appeared that he may have been under the influence, so I decided to pull him over for questioning and a breathalyzer test. His blood alcohol level was well over the legal limit to operate a motor vehicle, and we found that his license had been suspended. Before charging him, he pulled out his vape and took a hit from it mid-arrest.
You have no right to state an objection. This is not a proper criminal court. You have no lawyer. May the prosecution proceed with their statement.
Objection! Relevance?
I had no choice but to arrest him and slap him with a 90-day suspension from driving.
This is complete poppycock. How come kids get to drive that same car with a license and I can't?
You under the influence. There's a difference.
If I had been drunk, would I have been pulled over for my suspended license?
Yes, no one is allowed to drive without a proper driver's license.
And how come kids are allowed to drive the same car I drove without a license?
I don't know.
This is ridiculous. I shouldn't be charged.
Calm yourself, or I will hold you in contempt of the court.
Sorry, Your Honor.
You claim this violates your Section 9 charter right?
Yes, Your Honor.
Can you elaborate on your statement?
Sure thing. For starters, this arrest in general is ridiculous. I will bet my life that in the history of the entire universe, there has never been another 40-year-old man who has been arrested for driving a pink motorized Barbie car while intoxicated ever.
What about Paul Hutton in 2010? He did the...
Shut up, man. You're blowing my case. Anyway, my Section 9 charter right was violated because this arrest is way over the top. I was driving a toy car. Kids do it all the time and don't get arrested. They arrested me for something other kids do regularly, just because I'm a bit older than them. They did not have a valid reason to arrest me, violating my Section 9 charter right.
Kids don't usually drive intoxicated. What does the prosecution think of this statement?
He chose the worst possible argument to use in his favor. We had a down-tilting good reason to arrest him. He was intoxicated and causing a risk to the public. Under the Motor Vehicles Act, the pink Barbie car does classify as a valid automobile and can only be driven on roads with a valid driver's license, which he didn't have, and you must not be impaired while doing so. His Section 9 charter rights were not violated, and he should be charged with a DUI.
Oh, poop.
I agree. I rule in favor of the prosecution, meaning the defendant is found guilty on account of driving impaired. No! This can't be happening! I'll sue! I'll take this case to the courtroom of Judge Judith Scheinlin!
You are about to enter the courtroom of Judge Zenos Parosos. The people are real. The cases are real. The rulings are final. This is Judge Power. In this case, prominent New Brunswick lawyer said he took the wrong type of shrooms and found himself naked in downtown Moncton. Will he be found guilty, or will Judge Power drop all charges? Watch today's case to find out what happens.
Case number 67 on the calendar in the matter of R.V. Michaud. The defendant was found naked in downtown Moncton.
Well, I've heard a lot about you. Court is in session. Care to explain yourself?
I'm good.
Are you serious?
Yes.
Never in my 76 years of law have I heard that defense before.
Well, now you have.
I'm going to advise you not to use that defense, or I will hold you in contempt of the court, even though you are 100% allowed to use that as your statement.
Fine. I just don't want to talk because I'm sick, but whatever, I guess. I was bored one afternoon and decided to try out some shrooms for the first time. Thing is, my first time going to the drug dealer, after going to Cannabis NB for the first time, doing shrooms, they hit harder than expected. They probably sold me highly illegal shrooms that I totally did not buy on purpose. After that, it's a blur.
What a totally legit and compelling story to tell what happened.
Thank you. Anyways, finding me guilty of public nudity, causing disturbance, mischief, violates my Section 12 legal right that states everyone has the right to be subject to any cruel and unusual punishment. Since I did not choose to take the type of drugs I intended to take, I should not be found guilty for my actions. Since I entered an automatistic state, mens rea also doesn't apply, so you can't arrest me. I did not have a guilty mind.
A case of automatism. Guess at the end of this trial, we'll have to find out if automatism is a good defense in court. Does the arresting officer have an opening statement prepared?
Sue yourself!
Finally, people realize I'm a sir. State your statement.
Of course, Your Honor. While I was on duty, I saw a crazy naked man downtown. So, of course, I arrested him, and you'll never guess what he did in my backseat.
What did he do?
He pissed all over the backseat. High or not, his actions have consequences, and nothing will take back the image of a naked man pissing all over the backseat of a $60,000 car. Finding this immature man baby guilty does not violate his Section 12 legal rights. He would be receiving proper punishment.
I see. Good argument on your behalf. I'd like to see the drug test of Richaud. Let's see what we have here. What on earth? How did you mix up magic mushrooms and heroin? You don't even take both the same way.
How did you find this information out, Your Honor?
Objection, relevance.
You're the judge. You can't call objection.
All right, we're getting sidetracked. Has the defendant taken any magic mushrooms before?
No, Your Honor. I did not take them before in my life. I did not know what extent the automatistic state brought on by the hallucinogens would bring me. If I had known, I would have not taken it.
First of all, heroin isn't a hallucinogen, it's an opioid. Secondly, you know the risk of the drug before you're taking them, so the crime is still on you.
Yeah, but my precious Section 12 of the Charter rights will be violated if I'm found guilty.
We have been over this. You took the drugs that put you into an automatistic state of mind. Mens rea does not apply to you. Any punishment you will receive is just for your crimes.
Now that was compelling. Gotta admit, the arresting officer is persuading me to his side.
Wait! Give me a second to think.
What in tarnation is happening?
I got it! Section 10 of the Charter states that I have the right upon being detained to be informed of the reason of my arrest. I was not informed until 28 hours after being put behind bars. Not informing me of my arrest violates Section 10 of the Charter rights, which means I should be released back into the community.
I told you exactly why I arrested you the moment I put you in handcuffs. Maybe you don't remember to an automatistic state.
Oh, right. I got nothing.
Well, on that note, I find me show guilty of all charges, proving that automatism shouldn't be used as a proper defense in a court of law. Even if that means if an old woman with dementia killed somebody, they should still be put away behind bars regardless if they remember or not. Case dismissed.
But I did so well, though.
I know, but the arresting officer did so much better.
Oh, rats, this makes me want to get naked.
You are about to enter the courtroom of Judge Zenos Parosos. The people are real. The cases are real. The rulings are final. This is Judge Power. In this case, a Russian man committed a surprise crime. The twist? Nobody knows what he did because he speaks Russian.
This court is now in session. Will the plaintiff please give their opening statement?
You see, it all happened when...
Oh shoot, he's Russian. Anybody here a translator? I can't understand him.
Brother, I speak in English.
Since I can't understand him, I have no choice but to violate his Section 14 legal right of the Charter of Rights and Freedoms and not supply him a translator to offer a fair trial. The accused is found guilty of all charges.
And this concludes this week's episode of Judge Power. Tune in next week for another episode with more entertaining cases.
Yeah.